you are hardy souls. We had about 60 or 70 people RSVP for this event. Normally, we expect 20, 30% no-shows because of our idiosyncratic habit of having free affairs, free events. But this time, because of the weather and the parking challenges, we have even more of a no-show ratio than that. But you'll be pleased to know, Professor, that there were 60 or 70 people who really wanted to hear you.
Or said they did.
Or said they did. And Jay will see to it that they get a schedule of when this will be on the air. That's Jay Fidel in the back there doing the filming. And so this is our what has become annual J-term luncheon, where the Harvard Club and the Miley Plus League gathered to listen to the Harvard Club law professor who has agreed to come for the month of the J-term, the month of January, and teach a course here at UH Law School, thanks to the generosity and creativity of Frank Boas to my right, whose shindig this really is, and who's the person who's responsible for all of this. Our guest today is Richard Fallon, professor of law at Harvard, and you've all read about him in the email, so I won't go into too much detail, but I'm enormously impressed because he is as you know from the email, he went to Yale undergraduate school and to Yale Law School, and it's a remarkably inspirational example that someone with enough ambition, gumption, and creativity and energy can rise above a deficient education and wind up at Harvard Law School. So we're very proud of him at Harvard. He is a constitutional authority and has written extensively about constitutional law and the federal courts law. He's the author of The Dynamic Constitution and Implementing the Constitution, and he is a two-time winner of Harvard Law School's Sachs-Freud Award, both the years 2001 and 2006, which is voted annually by the school's graduating class to honor excellence in teaching. He's got some very fascinating remarks for us today, and so we'll have a time for question and answer after he's made those remarks. So I'm very honored to introduce Professor Richard Fallon from Harvard Law School.
Thank you very much, Archie, for those mostly kind introductory remarks. Everybody, I'm just absolutely delighted to be here. It's the first time I've been to Hawaii. It's such a beautiful place. Everybody has been so kind. My wife is here with me, my wife Jenny, and we're just enjoying it enormously. It's especially nice to be here at this time of year. On Friday morning we arrived and I went out to go jogging in jogging shorts and a t-shirt, and several people as I was walking through the hotel lobby apologized to me about how cold it was. The previous morning in Cambridge, Massachusetts, I had been jogging wearing 3 layers and saying to myself how grateful I was that it wasn't as cold as it had been the day before. Today, people here are complaining about how terrible the rain is. By my email, I received notification that Harvard Law School is closed today due to 18 inches of snow in Boston. And so even your hard weather is a good deal gentler and kinder and nicer to be in than what I'm used to. With respect to my deficient education, I'm not unaware of that. In fact, in some ways it was brought home to me, the way the world views Yale in comparison with Harvard. I think many years ago when I was an undergraduate at Yale, I'd grown up in Augusta, Maine, and it was one of my early trips home to Augusta, Maine from New Haven. And I met on the street an older gentleman that I had known who had been helping to run a boys' club that I'd participated in years before, and he greeted me with great warmth. "Oh, Dick, good to see you. So good to see you. Where are you? What are you doing?" And I said, "Well, I'm in my first year at Yale." He said, "Yale? can't say I've ever heard of it. I thought you were at Harvard or someplace like that. which of course left me ever after realizing that there is no place like that. There is Harvard, and there is someplace else, at least in the eyes of some. I don't count myself necessarily among that number, but I have come to recognize things for what they are. Recognize things for what they are. In some ways, I guess that will be what I'm going to talk about today for the next 15 or 20 minutes or so. I'm mostly going to be talking about the Supreme Court and the Supreme Court as an institution to protect minority rights, somewhat in general terms, and then at the very end of my remarks, I'll try to bring things down to earth a little bit by talking about the likelihood that the Supreme Court of the United States will, before terribly long, uphold a constitutional right to gay marriage, either in the case coming out of California that most of you have probably read about, or in some other case. And in order to talk about the Supreme Court and protecting minority rights, and to talk about it in terms of how things are, or at least how I think they are, I want to talk briefly through each of three perspectives on what the Supreme Court does with respect to minority rights, the third of which I think will be a corrective to the first two, informative though the first two are, and will give you a sense of my own view. So with respect to three perspectives, the first perspective is one that I encounter year after year after year recently teaching a freshman seminar to Harvard freshmen when we have the first session of the class and I talk to them about the Supreme Court and what do they think the Supreme Court is and what do they think that the Supreme Court does. And in repeated conversations with them, I've put together what I think of as the high school civics book view about the Supreme Court and minority rights. And as they talk to me about what they've learned in sophisticated high school courses, what they tell me is this. They learn that we have the best Constitution in the world. We have the best Constitution in the world, somewhat in a double sense. It's the best Constitution in the world because it gives us political democracy, which is a very good thing to have. But everybody understands that if you have too much democracy, the majority is prone to certain periods to run roughshod over the rights of minorities. And so we've got the best Constitution in the world because it gives us minority rights, and it gives us pretty much the right minority rights. We've got the rights of freedom of speech that we ought to have. We've got the rights of freedom of religion that we ought to have. We've got rights protecting racial minorities from discrimination. We've got rights protecting women from discrimination, and other groups are protected somewhat too. Indeed, the Supreme Court may be on the way to recognizing a very broad set of equal rights for homosexuals. But what the court will be doing, if it does that, is interpreting the Constitution, doing what is just, standing outside of politics, because once again, always remember, the reason we need a court is to make sure that minority rights get protected against what's going on in politics. That's what our Supreme Court does. That's the glory of our Constitution. And if there's one case that everybody knows about that exemplifies what the Supreme Court does, it's of course Brown against Board of Education. So the Supreme Court protects rights of minorities because minorities need to be protected from majorities, and they do it as a matter of honest interpretation of what the Constitution meant all along. Perspective one. Perspective number two is what I think of as the realist or political science perspective. Political scientists today are writing a very great deal about what the Supreme Court does, writing nearly as much as law professors write, and what they say tends to be quite starkly different from what law professors on the whole write. But the political science realist perspective would go something like this. Let's start by putting into question the proposition that the Constitution really does clearly protect any significant right. Yes, the Supreme Court insists that people have rights from time to time, but during World War I, for example, people were sent to jail for criticizing the United States war effort, and as historians were quick to demonstrate in holding that that was constitutionally permissible, the Supreme Court didn't clearly contravene what would have been the original understanding of the Constitution. In 1954, the Supreme Court in Brown against Board of Education famously held race discrimination unconstitutional, but in 1896, in a case called Plessy against Ferguson, the Supreme Court had ratified the so-called separate but equal doctrine, and when historians go back and look at the original understanding, so-called, of the 14th Amendment, they find a lot of awkward evidence for the proposition that maybe race discrimination in the schools was consistent with the way the Constitution was once understood and maybe understood by the people who wrote it. So the political scientists say, look, let's be honest. We've got a substantially indeterminate Constitution. Reasonable people could reasonably interpret it in different ways as protecting particular claimed rights or not particular claimed rights. So what does that mean to do? That means that the justices get to do what they want to do. They impose their political preferences. So rather than interpretation of what the Constitution truly and honestly means, we get judges imposing their political preferences, and their political preferences tend to be pretty much consistent with prevailing majority sentiment in the country from time to time. They're just people of their time. They're appointed by a politically elected president, confirmed by a politically elected Senate, and it therefore shouldn't be very surprising that at a time when political majorities don't want particular rights enforced, they don't tend to get enforced. World War I, people are very alarmed about the Red Scare, fearful that the war effort will go badly if there can be domestic criticism, so the Supreme Court allows people to be sent to jail for criticizing the war effort. Plessy against Ferguson decided in 1896. Well, in 1896, what white Americans wanted to have racial equality enforced, it certainly would have been a very unpopular position. Korematsu against the United States, you know, of the Japanese internment during World War II. Political majorities, fearful in the early stages of World War II, want to have the other-looking people of Japanese descent interned, and the Supreme Court upholds the internment. So one could go on in this way. The claim of the realist political scientists wouldn't be that rights never do get protected. Of course they do get protected, but they tend to be recognized and protected when, but only when, they are rights that a majority of Americans are likely to want to see protected anyway. And so, by 1954, Brown against Board of Education, most Americans have come to believe that race discrimination is wrong. Race discrimination, of course, continues to be practiced in some parts of the country, notably the South. But if you look at opinion polls, most Americans have come to think that race discrimination is wrong. Freedom of speech has come to be enforced by the courts, mostly in a time in which there has been broad popular consensus for the idea that there ought to be broad freedom of speech. Women's rights, I mentioned earlier, the Supreme Court upheld equal protection rights for women for the first time during the 1970s. So the 1970s, well, what's going on in the 1970s? Well, we're coming to the climax, or maybe we're even just beyond the climax, of a women's movement that had led to broad changes in American society. I was in the Yale College class of 1974. It was the second Yale class to have women. Women are being admitted to major universities. Archie said Harvard College was co-educated. Harvard and Radcliffe put together in 1976. So you see, it's at the time when people are beginning to recognize anyway that men and women are equal, that the Supreme Court begins to say, well, there's a right for women to be treated equally to men. So mostly the political science realist story goes, rights get protected when political majorities want them protected. And then just the question, well, what if some aberrant set of Supreme Court justices decided, well, we want to insist on some rights, insist on the enforcement of rights that really would be fiercely opposed by prevailing political majorities. And the realist political scientists say, well, it's hard to know in a certain way because there really aren't very many cases like that. But let's just imagine that it's 1896 and the Supreme Court in Plessy against Ferguson says whites and blacks have to be treated equally, no more discrimination in schools, no more discrimination in railroad cars, which is what Plessy against Ferguson involved. No more prohibitions against interracial marriage. Suppose the Supreme Court had said that. And what the realist political scientists say is one way or another, those decisions would not have stuck. They would have been defied. They would have been so politically controversial that what the Supreme Court was doing would have become a leading issue in presidential campaigns. Presidents would have run for office crusading to replace the justices of the Supreme Court who had inserted their own crazy ideas into our Constitution, and the decisions would have been undone. So say the realist political scientists. Now, my own view is that a sensible account of what the Supreme Court does, an honest account of what the Supreme Court does with minority rights, has to take some significant account of the political scientist realist view, but it doesn't appropriately absorb it entirely in undiluted form. So here's what I would say about the Supreme Court and minority rights. First, it just does have to be recognized that with respect to the kind of rights that the Supreme Court deals with, there at one point in our constitutional history are often very plausible arguments on both sides, and the court has to make decisions that require value judgments. Call them political or call them something else, but they definitely require value judgments. That was what was happening in Brown against Board of Education. That was what was happening with women's rights. Something similar happened with respect to most of the First Amendment rights that we now recognized. But though that is so, I think one of the things that the political science account leaves out is that the Supreme Court is a reasoning, deliberative institution that has to explain what it is doing in particular cases and to talk about how what it is doing in particular cases is or is not consistent with what it is doing in other cases. So once rights get articulated, even unpopular groups tend to get the benefit of them. We don't have freedom of speech for the sake of the Ku Klux Klan, but once we have freedom of speech, the Ku Klux Klan benefits from it. We probably don't have all of the freedom of speech that we have for the benefit of people who wanted to crusade for civil rights, but when the rights were recognized, they were available to the people who wanted to crusade for civil rights. We don't have rights of criminal defendants specifically designed for particular criminal defendants that the public is outraged at some particular time, but once we've got them, they do tend to be enforced pretty consistently across the board, and we get some benefit from minority rights that way. Second, I do think it's true that justices are creatures of their times. They tend to be appointed by presidents who are in touch with the prevailing political currents of their times. And so it really shouldn't be any surprise. I think we just have to recognize this, that we don't get Brown against Board of Education till 1954. We don't get women's equality rights until the 1970s. If we're on our way to getting a broad panoply of gay rights, we don't get them until sometime beginning circa 1996, when the Supreme Court uttered its first opinion upholding rights, equal protection rights against certain kinds of discriminations for gays. But even if the Supreme Court is not very far ahead of the prevailing national median opinion, where the central United States voter is, very often the Supreme Court enforces minority rights in parts of the country where those rights otherwise would not be observed. So again, Brown against Board of Education made an enormous difference in the South, at least once the political officials were behind it. There were pockets where women's rights weren't being respected in the 70s and 80s, and in those areas the Supreme Court decisions made a difference. Insofar as we're getting gay rights recognized by the Supreme Court, there are certainly places in the country where those rights wouldn't be respected. That is certainly not nothing. Certainly not nothing. The third thing that I would say is, although the political science realists are undoubtedly right that there are certain things that the Supreme Court just couldn't do and make stick, even if they wanted to, there are a number of things that they can do. There are a number of things that they can do because the issues aren't ones that the public care about so deeply that what the court did wouldn't stick if the court wanted to do them. And we're especially likely to get Supreme Court justices who are going to push in that direction when we've got political leadership in the country, from presidents and members of Congress who care about minority rights. Now, given the opportunity to do things, courts don't always do them. I actually think Korematsu against the United States decided not in the early days of the war, in 1942, for example, but decided in 1944 when the government was about to release the internees from the detainment camps, is a situation in which the court could efficaciously have ruled the way differently from the way that it did, but it didn't, so the court doesn't always stand up for minority rights when it's got the political breathing space within which to do so, but sometimes they do. And I think one of the reasons that judges are more likely to do so than other officials is because, as I said in passing earlier, it's the nature of the judicial job to ask, is what somebody is claiming or opposing in a particular case consistent or inconsistent with the values and principles that have been established in other cases. And I think people asking questions of that kind are probably more likely on average to say, yes, this particular person from a particular minority group claiming a right is claiming something that actually is at least implicitly recognized by things that courts have done and said in other cases. And so I think that our courts in the United States have been forces for the good in protecting minority rights that as a matter of political morality really ought to be respected. To that extent, I stand with the civics book perspective, but a lot of what I have said includes a little bit, or maybe more than a little bit, of dampening realism, because I think that's just the way things are. And if we want to understand what our constitutional law is and how it works, we've got to understand our constitutional law in such a way that we think we've got constitutional law that is real law, but is separated by politics only by a permeable barrier. So I said I would try to finish by bringing this down to earth a little bit with just a very few remarks about gay marriage. 30 years ago, 25 or 30 years ago, a judicial decision, a Supreme Court decision upholding a right to gay marriage, I think would have been outside the politically constructed bounds within which courts operate. If a court had rendered the decision then, it wouldn't have stuck. It would have been defied in many states. It would have been a campaign issue. Justices who would overrule the decision would have been brought in. Today, it's totally within the bounds of the politically plausible. There are plausible legal arguments both ways, and that means that it is a situation in which the political, in one sense of the term, views of the justices really will matter. And behind the views of the justices stand the views of the political constituencies that resulted in the particular justices being in the court, on the court in the first place. And so the easy part of the prediction, there are 4 justices of the Supreme Court appointed by conservative Republican presidents who under no circumstances can I imagine possibly supporting a claim of constitutional right to gay marriage. On the other hand, there are 4 justices of the Supreme Court appointed by Democratic presidents that I would be pretty confident would be ready to recognize a right to gay marriage. So if I'm right in those predictions, then the situation is one not unfamiliar to those who follow the Supreme Court closely, and that is a decision on the issue, if it were made by the court that we have today in deciding the case in the near future, would be decided by 5-4, with the decisive vote probably being cast by Justice Anthony Kennedy. Kennedy, in his tenure on the court, Kennedy was appointed by President Ronald Reagan after the Bork nomination had failed. He is in many ways a very conservative man. He is in many ways a very idealistic man, and somebody who has emerged as a kind of surprising champion of gay rights in the time that he's been on the court. Now, I said there are plausible legal arguments both ways, and here's the way, in crudest terms, I would understand the plausible legal arguments. The legal argument against a right to gay marriage begins and almost ends in the idea that it was not historically understood that there was a right to gay marriage. And if you look at the original understanding of the Constitution, there is not any provision, the original understanding of which would have protected a right to gay marriage. We don't always follow the original understanding with respect to the interpretation of constitutional provisions, but some justices of the Supreme Court are committed to the idea we should most of the time, and I think that's what the 4 conservative Republicans would say. if people look around at the surrounding legal doctrine, which tends to say that any time the government discriminates against a group of people, it's got to have a good, legitimate, non-religious, but rather secular reason for enforcing the discrimination. I think the argument is very strong that there is no good, persuasive, non-religious reason to want to exclude gay marriage. And my guess, and it's really only a guess at that point, is that Kennedy, who was not always an originalist and who has upheld rights to non-discrimination for gays in some other context, would join with the other four to make a 5-4 majority for a right to gay marriage. But I don't want to end there. I will only take 2 more minutes, but I don't want to end there. And I don't want to end there because although I love my job as a law professor, the days that it seems worst to me are the days when I think that such expertise as I have is expertise into the psychology of Anthony Kennedy. I am not trained as a psychologist. And so not wanting to end there, what I do want to end with is to say this. 25 years ago, this would have been an easy case, no right to gay marriage within the then established constitutional doctrine and then prevailing political understandings of fairness in the country. 25 years from now, I would pretty confidently predict that it will again be an easy case, but it will be an easy case the other way. That there will be a right to gay marriage because all the demographic trends are pushing in that direction. I know there have been a number of states that have recently put provisions into their constitution saying that there's no right to gay marriage. But if you look at opinion polls, people under 35 are overwhelmingly in favor of the idea that there ought to be across the board equal rights for gays. And when they're the prevailing dominant political majority, there will be colorable legal arguments for a right to gay marriage, and that's what the constitutional law would be. I would be very confident. And so, that being the case, well, maybe it's a little tempting to say, maybe it doesn't matter so much what the Supreme Court does now. It's only a matter of time for this minority. But then I want to say, no, that's not what I think, because I think that for people now, it does matter, just as for African Americans in the 1950s, before the country was totally on board, and for women in the 1970s, before the country was on board. If there was going to be progress, it was going to be progress driven by the courts. And so the Supreme Court, I think, in one way, is an effective guarantor of minority rights only within a relatively narrow space defined by time and public opinion. But within that narrow space, I actually think the courts can play a very significant role in protecting minority rights. Affirmative action, if you think that the role of the Supreme Court is to protect minority rights, then affirmative action looks odd. And it looks odd because what you see in the case of affirmative action is the Supreme Court protecting the rights of whites who aren't a minority in the United States. The time may be coming when there will be a minority in a few states, but it's the Supreme Court projecting majority rights rather than minority rights. They're protecting majority rights rather than minority rights on the basis of a vision of fairness. And so I don't mean to be trivializing this, but it is not the protection of minority rights. It is entirely plausible to think that if there's any group that ought to be able to protect themselves through the political process without the special solicitude of the courts, it would be whites in the context of affirmative action. Affirmative action, as you undoubtedly know, is unpopular and probably becoming more and more unpopular all the time. I think the fact that the Supreme Court has become more hostile to affirmative action over time rather than less hostile to affirmative action over time reflects the way in which law is separated from politics only by what I called a permeable barrier. And what we see in the case of affirmative action, in my view, is a Supreme Court acting on the basis of a vision of fairness. And again, I don't mean to trivialize this. There's no crass self-interest about this for the Supreme Court, but a vision of fairness that is more solicitous than the vision of fairness that I would endorse of the interests of the relatively most historically advantaged group in the society and working to the disadvantage of groups that have historically been more disadvantaged. It's certainly one of those cases where the Constitution doesn't speak crystal clearly one way or the other, and judges have to make value judgments, and the value judgments that they tend to make tend to reflect the prevailing value set of the American majority. One of the things that I said and have meant to emphasize is that with respect to many of the kinds of questions that reach the Supreme Court, there is no one crystal, objectively clear, right constitutional answer. People have to exercise judgment in order to figure out how the Constitution is appropriately interpreted and applied. And I think the context of national security is one where judges and justices do have to make practical judgments about what is a sensible, fair, and appropriate way to understand constitutional guarantees from time to time. In the immediate aftermath of 9/11, if cases had come to the Supreme Court in a situation in which nobody had any idea what the scope of the threat was and lots of people were terrified, then I think it's relatively easy to do the counterfactual prediction. If that had happened, then you would have found a Supreme Court that was not doing much, if anything, to assert in a way contrary to the wishes of the political branches and the frightened public that people had very broad rights. As time stretched out from 9/11, I think what we've seen, especially in a series of cases involving the rights of the Guantanamo detainees, is that the Supreme Court has been willing to go cautiously further and further, but still only cautiously, not having gone terribly far, but cautiously further and further in protecting those detainees' rights. And my guess is that so long as the situation doesn't seem, I can see that I'm bothering you as I move around. I will try to stay here. If the situation seems less terrifying, then we will find a Supreme Court that will be more willing to impose, to stand up for guarantees of individual rights, but by a hair-thin margin, with Justice Kennedy, again, probably being the one who will cast the decisive vote in most of the cases. And if there were another very serious, very, very serious terrorist attack, all bets would be off. So let me say one more further thing, maybe something that I don't need to say, but it may be useful amplification of some of the points that I was meaning to make earlier, and speak to your question in particular as well. When I talk about the political scientist's perspective, one of the political scientist's favorite phrases in talking about the Supreme Court, and it's actually a very helpful phrase to have in mind to understand what the court is doing and to predict what the court will do in the future, is to say the Supreme Court is a they, not an it. And so what will the Supreme Court do? Well, maybe the right way to think about that is we'll say, think of it not as one entity, but as there are 9 people, 6 men, 3 women. What will those specifically nameable 6 men and 3 women do? And with respect to the questions that you're asking, there are 4 justices, all of whom happen to be men, all appointed by Republican presidents, who will take a very pro-executive power to keep the country safe stand. And so to get to 5, then you've got to get every other one of the 5 to go along. And with respect to some of the questions that you raise, it would be very precarious to try to find a way to count to 5. Again, the way to think about it is not an undifferentiated court, but 9 justices. And where the tipping point is, where the balance of power is, when you've got a court 5 justices appointed by Republican presidents and 4 justices appointed by Democratic presidents. We've got to be realists, at least to that sense, or we're just naive dupes in our effort to understand the way our constitutional law works. That the Supreme Court will be an elite institution. An elite institution, start with the fact that everybody who's going to be on the Supreme Court, I think, though the Constitution doesn't dictate this, will be a lawyer. And so that will mean somebody who's had 4 years of undergraduate education, 3 years of law school education, probably has done something really pretty distinguished in his or her legal career. So I think it's just absolutely foreordained that it is going to be an elite institution in the sense that I just described. Then we could talk about, and this would be a very interesting, fascinating question, but it would take a long time to get through. Within the set of highly educated lawyers who have done really terrific things, what kinds of diversity would make a difference for the good, and what kinds of diversity wouldn't make any difference at all? So if somebody said, well, I think we need a red-headed justice, we would say, well, that's absolutely ridiculous. Some people are worried that the Supreme Court today consists entirely of Catholics and Jews, that there's no Protestant on the Supreme Court. Would that make a difference? I'm inclined not to think so. Confession time here. When I was applying to undergraduate school, I applied to Harvard College and didn't get in. I did get in at Yale. I expected I was a kind of a marginal candidate, and I expected as a marginal candidate I was probably helped by the fact that I had grown up in the state of Maine, because Yale liked the idea of having people from every state. So would it be a good thing to have more geographical diversity in terms of where the justices come from? I'm thinking about this as a mainlander, and I'm inclined to think no, though here on the Hawaiian Islands you may have a different view about that. So I've said I think probably religion doesn't make so much difference. So what is going to make a difference? Now, we've got 3 women on the Supreme Court. I think that's very good. I think that there are a couple of cases that I could actually point to by name and say that I think it probably made a difference. Justice O'Connor breaking with the conservatives in one case, Justice Ginsburg asking a line of questions in oral argument that by the account in the New York Times seemed to just turn around 180 degrees the way that some of the other justices were thinking about the constitutionality of a strip search of a young woman. Justice Breyer had said, well, I used to be in a locker room and people were snapping towels at each other and there was no awkwardness about people being naked at that time in their lives. This was a high school student who had been strip searched, and Justice Ginsburg pursues a line of questioning indicating she thinks it's really quite different for a young woman being strip searched by an older person in a situation in which there is a tint of accusation about what's going on. So yeah, I think that that's an important kind of diversity. And I've just rambled on, but I hope I've said enough. I hope I've said enough to vindicate what I said at the beginning, that we could have a long and interesting conversation about what kinds of diversity would and wouldn't be valuable, but that it's not as if we're going to, you know, you could imagine that somebody would say, well, I think we ought to have a homeless person. Think what a different kind of perspective that would bring. But that's just not going to happen. It's just not consistent with the way the institution is structured and understood. The baseline, the starting point in this country would be anybody can say anything he or she wants to say unless there's a law against it. You see, because if there's not a law against it, then a court can't say, well, I don't like what you just said. Police officer drag him off to jail, or bailiff drag him off to jail. So if there's suppression of speech, it doesn't start with the courts. It starts with people who make laws saying that it is impermissible under the law to say certain things. Now, what has happened when Congress and state legislatures have enacted laws forbidding people to say certain things is that with overwhelming consistency over the past 50 years or so, before that it would have been a somewhat different story, but with almost overwhelming consistency over the past 50 years or so, the Supreme Court has invalidated, said nearly every law stopping people from saying certain kinds of things is unconstitutional. Now, so I've been talking about constitutional law. John Stuart Mill, in his famous essay on liberty, talked about the tyranny of public opinion. And Mill was very fearful that in the society in which he lived, there would be lots of people who would be afraid to say things, not because they would be sent to jail for saying them, but because their fellow citizens would think badly of them if they did. Now, maybe you think that's a problem, but that is a problem, if it is a problem, that is totally beyond the capacity of the courts to solve. The state of the law is that you have to start and find what particular law you have in mind that prohibits speech. But the state of the law from the perspective of constitutional doctrine is that any law that restricts people from saying something based on the content of what they want to say is unconstitutional unless it is, quote, necessary to protect a compelling governmental interest. And the Supreme Court, when particular laws have been put before them under that test, has repeatedly, time after time, said no compelling interest here, no compelling interest here, no compelling interest there. There's a certain sense, there on the other hand, and so I want to get to that, I think I'm just sort of missing you. If you could tell me one person that you know of who's in jail somewhere for having spoken along the lines that you described, I'll be astonished. So can you just give me an example? Who are you thinking of who's in jail for having spoken? Who's in jail for speaking about abortion game? Nobody. Nobody. The thing that I want to say is not directly responsive to your question, but is triggered by it, is I hope that I am clear that I don't think every constitutional issue is one in which everybody has an opinion and everybody just votes his or her opinion. When I'm talking about the necessity for political judgment, I'm talking about a relatively narrow set of cases that overwhelmingly includes the kinds of cases that come to the Supreme Court. And there are very many issues that if they ever got to the court, and they don't, the court would decide by 9-0. And so it's not with respect to every issue that you've got the Republican bloc and the Democratic bloc, and they're going to go in predictably different directions. There are some of those questions. One of the, and now I am going to try to answer your question. So the question is about the Citizens United decision. This was a decision by the Supreme Court about exactly a year ago that invalidated nearly all efforts by Congress to restrict the expenditure of money by corporations, money directly by corporations, right out of the corporate treasury, to try to promote the election of particular candidates. And partly as a result of this decision and partly as a result of some previous decisions by the Supreme Court invalidating other restrictions on expenditures of money to try to influence the outcome of political campaigns, we are seeing unparalleled flows, gargantuan flows of money into the political process to try to influence the outcome of elections. And if one just looked at the 2010 elections as a kind of snapshot, then one might say, well, that money overwhelmingly seemed to have done more good for the Republicans than for the Democrats, and is the effect of this decision going to be to skew the way that our politics works? And I'm not enough of a prophet to know the answer to that question. I think, in answering an earlier question, or doing some earlier talking, I said, let's frame current problems by thinking how things would have been 25 years ago, how things will be 25 years from now. Looking out over the time horizon, I'm actually a little bit optimistic that our political campaigns will be done in a different way, and that money won't be so influential then as it is now. Think about the Internet. Think about the opportunities for people to reach out and to try to influence each other in their thinking about political issues with virtually no expenditure of money, just being able to push buttons. Think of blogs as increasingly a place where people go to get their political opinions instead of watching the nightly news on television and seeing what ads are run in conjunction with the nightly news. Think of internet fundraising as a way to tap the money of the little person, and maybe by tapping the money of the little person, being able to neutralize to some extent expenditures of money by large corporations. To some extent that happened in the Obama campaign in 2008. And so that's all I have to say, and it's not a very good answer. There is a feedback loop, I think, that is operating now. And how important that feedback loop will turn out to be over time, I don't know. So it's a sad reflection of the state of our politics that these confirmation hearings play out as they play out. They play out, I think there is no doubt, as charades in which the nominees are required to perjure themselves by standing up there and claiming never to have thought about particular issues that you know that, of course, they have thought about, and to claim that it would be inappropriate for them to comment on some issues because those issues might come before the court, whereas if asked to comment on other issues. Do you think the Supreme Court decided correctly in Brown against Board of Education, even though the court could conceivably be asked to overrule Brown against Board of Education, they won't be able to restrain themselves from going on for an hour about what a wonderful case Brown against Board of Education was and how terrible it would be if it were ever overruled. So why does this happen? This happens because, as you say, Judge Bork, nominee Bork, responded relatively candidly to a number of questions and was denied confirmation partly as a result. But our politics is so much worse today than it was in 1987 when Bork was nominated and his nomination was rejected, that in terms of an honest conversation, none of those senators wants an honest conversation, or if, there may be one or two who do, but what most of them want is to score political points. And so there are some of them who would love to hear the candidate, the nominee, speak clearly about what a wonderful decision Roe against Wade is, because he or she wants to be able to pound the table about how wonderful Roe against Wade is. But others are just looking for the gotcha statement that they'll be able to wave before their constituencies and to say that the nominee is absolutely unfit for service as a result of. And so, sad confirmation, sad reflection of where we are. If you ask the question, how many senators' votes were changed from the senator's predisposition headed in as a result of the recent totally non-revelatory Kagan hearing, then I think the answer is close to zero, if not absolutely zero. Virtually no votes were changed. Now imagine that somehow somebody gave a truth serum to the nominee and Justice Kagan had answered every question with full candor. How do you think the vote distribution would be different? And I would be very surprised if it differed at all. So I just want to use the phrase that I used before about reflection of our politics rather than an isolated flaw in our politics. The system needs to get better in some more nearly global sense. And when politicians begin to talk with candor and civility to their audiences and to each other, we'll be in a much better country. And in that much better country, we'll start to have much better conversations at the time when people are nominated to the Supreme Court.
Thank you very much.
Okay, thank you.
Thank you so much. Thank you, Professor Fallon. I just wanted to acknowledge Dean Seufer, whose guest we are today, Cindy Quinn, who helps him out here, and who got the temperature up from a 55 before up to where it is now, for all our company, and to Mrs. Fallon, who was gracious enough to come and attend today. Thanks so much.